Welcome to our Family Law Essentials virtual information session. My name is Ali Collier and I'm the Community Legal Education Worker for the Mallee Family Care Community Legal Centre. And I have with me our Principal Solicitor, Leanne Bosman. Please note that this information is general in nature and it is not intended to replace individual legal advice. The information is current as at the 20th of May 2024 and includes changes to the Family Law Act which commenced on the 6th of May 2024. Family violence is referred to in this session, however it is not its direct focus. Family violence may make some options referred to in this session unavailable to you, however information about the family law system will still be beneficial. Separation can be a very difficult time to navigate and people are often given advice by well-meaning family and friends, which unfortunately is incorrect. Today we are going to talk about some of the essentials of separation, children and property, and bust some common myths. Leanne, if I'm a client coming to you for a first appointment after separation, what advice would you give me?
Some of the immediate things to consider are where your children live and who will take care of them, how you and your former partner will support yourselves and your children, what, how and when you will tell the children and other family members and friends about the separation, who will pay outstanding bills and debt, who will stay in the house, how will the rental mortgage be paid, what will happen to any joint bank accounts, what will happen to house, car, furniture and other property.
There are so many things to think about. Does everyone need to go to court to sort it all out?
Most people don't need to go to court to make arrangements for their children or to divide property or finances after separation. There is no need for parenting or financial arrangements to be decided by a court, unless it is not safe to make your own agreement or after making a genuine attempt to resolve your dispute, you still can't agree.
Going to court isn't the best option for most people, is it?
Going to court is expensive, time-consuming, stressful. You may not get the result you want. The court expects people to make genuine attempts to engage in dispute resolution, if it is safe to do so, before starting court proceedings. This can be by private discussions, using a private mediator, engaging solicitors, or through government-funded family dispute resolution services like those at Mallee Family Care Family Relationship Service. Court should always be a last resort. When it is safe to do so, there is a better way to separate.
Leanne, what are some key points when you have children to consider?
Even though you are separating, both parents are the most important people in your child's or children's life. When there are no safety or risk issues, the best arrangements for the future are those where your child continues to have a relationship with both parents and other family members. Both parents participate in joint decision-making about major long-term issues. Your child lives in a safe environment with no violence or abuse.
What things do you need to consider when making parenting arrangements for your child?
Every family is different, so the arrangements that work for your family may be different from other families. Try to make arrangements that work best for your child. You will need to consider the age of your child, which is very important in deciding what arrangements will work. Establishing a regular routine so that the child knows the routine and what to expect when, but also being flexible when required. Giving plenty of notice to your co-parent if you wish to change the routine, for example, for special occasions. How the child's time will be spent with other significant persons in their life, such as grandparents and other relatives. Who will look after them after school and where will they spend school holidays? Any other things such as choice of school, healthcare, sport or religious matters, and how to ensure the child continues to enjoy their culture.
What are the main ways that people can make arrangements for their children after separation?
If it is safe to do so, it is generally best if you can reach your own agreement with your co-parent. Making your own agreement is often best for your child, you and your co-parent. It will save you both time, money and stress.
There are three main ways you can make arrangements for your child after separation. Can you explain these for us?
Sure, there are informal arrangements where parents just make arrangements between themselves. There's parenting plans and parenting orders, including by consent. What sort of parenting arrangement you make may depend on how you and your co-parent come to the agreement. If you agree on arrangements, you can make a parenting plan or seek to formalise your agreement by applying for consent orders. If you cannot agree on some issues, you can use dispute resolution or mediation to help you resolve any issue in dispute. If you cannot reach an agreement, you can apply to the court for parenting orders.
If you do end up in court, people need to be aware that there have been some recent changes which took place on the 6th of May 2024. Can you tell us a bit about these new laws?
The Family Law Amendment Act 2023 sets out new laws about what a court must consider when determining what is in the child's best interest and how separated parents are to make decisions about long-term issues for their children. When determining any dispute about children, including about with whom a child should live or spend time, who should make decisions about a child, and matters like where a child should go to school or whether a child should have a medical procedure, the court regards the best interest of the child as its paramount consideration.
And there are some factors that the court considers when deciding parenting arrangements.
The court will consider 6 factors to decide what parenting arrangements will be in the best interest of your child. These factors include the safety of the child and people who care for the child's views, the developmental, psychological, emotional and cultural needs of the child, the capacity of each person who will be responsible for the child to provide for the child's development, psychological, emotional and cultural needs, the benefit to the child of having a relationship with their parents and other people who are significant to them, like grandparents and siblings, and anything else that is relevant to the circumstances of the child. Decisions about how much time a child spends with each parent depend on what is in the best interest of the individual child.
Many people presume that parents are entitled to equal time with their child. Is this the case?
While many people believe that parents are entitled to spend equal time with their child, this has never been the case under Australian law. The presumption of equal shared parental responsibility has also been removed with the new amendments. The removal of the presumption means the court no longer must presume it is in the best interest of the child for the child's parents to be required to make joint decisions in relation to major long-term issues. These changes clarify that decisions about parental responsibility should be based on what is in the best interest of the child and the circumstances of the case.
Are children's voices considered when the court is making decisions about them?
The court process is designed to balance the need to protect children from conflict with the child's right to have a voice in decisions being made about them.
Leanne, there's often questions about grandparents and how separation might affect their ongoing relationship with their grandchildren. Can you tell us a bit more about that?
The law recognises the importance of a child having a relationship with grandparents, including after the child's parents have separated. The Family Law Act recognises that, as long as it is in their best interest, a child has the right to spend time and communicate with their parents and other people important to them, such as grandparents, relatives and members of extended families.
Do people need a lawyer to make arrangements for their children?
You are not required to be represented by a lawyer or to seek legal advice before entering into a parenting plan or applying to the court, or if you have been served with an application. However, family law is complex and getting legal advice will help you better understand your rights and responsibilities.
A key message here is to keep your focus on your child's well-being rather than what you think is fair to you. Financial and property matters are another thing that people need to consider when separating. What are some key points people need to consider?
When people separate, whether from marriage or a de facto relationship, they usually need to sort out how to divide their property and debts. One person may also need financial support from the other, either for themselves in the form of spousal or de facto maintenance, or for their child or children in the form of child support or child maintenance. If it is safe to do so, it is generally best if you can reach your own agreement with your former partner. Making your own agreement will save you both money, time and stress.
How do people go about making these arrangements?
There are various ways you can make arrangements to divide your finances after separation. If you agree on arrangements, you can seek to formalise your agreement by applying for consent orders or by making a binding financial agreement. If you cannot agree on some issues, you can use dispute resolution or mediation to help you resolve any issue in dispute. If you cannot reach an agreement after dispute resolution, you can apply to the court for financial orders, including orders relating to the division of property and payment of spouse or de facto partner maintenance.
Are there time limits that people need to be aware of when making an application to the court for financial orders?
Yes, there are. Different time limits apply for making an application to the court for financial orders depending on your individual situation. If you were married, applications for property adjustment must be made within 12 months of your divorce becoming final. If you are in a de facto relationship, your applications for property adjustment must be made within 2 years of the breakdown of your de facto relationship. If you want to start proceedings out of time, you must ask the court for leave. This is not always granted. Time limits do not apply to child support and child maintenance applications.
When we're talking about financial settlements, how much do people have to disclose to the other party?
Parties must disclose all sources of earnings, interest, income, property, and other financial resources. This applies whether the property, financial resources, and earnings are owned by or come to the party directly or go to some other person or beneficiary, or are held in corporations, trusts, company, or other such structures. Also required to be disclosed is information about any property disposal, whether by sale, transfer, assignment, or gift that was made in the year immediately before the separation of the parties or since the final separation.
There can be serious penalties for failure to provide full and frank disclosure. Can you explain a bit more about that?
That's right, Ali. The court may refuse to allow you to use information or a document as evidence in your case. They may stay or dismiss all or part of your case. They may order cost against you. You may also be fined or imprisoned if you're found guilty of contempt of court for not providing full and frank disclosure. There is no specific formula used to divide your property and finances. It depends on the circumstances of each relationship. If you are not able to reach an agreement at dispute resolution, your matter may progress to a hearing.
If people can't agree on a financial settlement, how does the court decide?
The general principles are the same regardless of whether the parties were in a marriage or a de facto relationship and are based on what is commonly referred to as the 4-step process. Step 1 is to identify your assets and liabilities. The assets and liabilities of you and the other party individually and jointly, what you own, what you owe, and what they are worth. This also includes superannuation. Step 2 is to assess the contributions you both made. Direct financial contributions by each party, such as property you each had when you began to live together, your wage, salary earnings while you lived together. Indirect financial contributions by each party, such as gifts and inheritances. Non-financial contributions to properties, such as renovations to a home, management of investments, or running a business. Contributions to the welfare of families, such as caring for children and doing housework. Step 3 is to consider your future needs. A court will take into account things like age, health, financial resources, care of children, and ability to earn income. Step 4 is to evaluate the overall outcome of the agreement. Is it just and equitable? Is it fair to both of you? It's important to remember that the way your assets and debts will be shared between you will depend on the individual circumstances of your family. Your settlement will probably be very different from others you may have heard about.
Do people need to have a lawyer to finalise their financial settlement?
You are not required to be represented by a lawyer or to seek legal advice before entering into consent orders or applying to the court, or if you've been served with an application. However, family law is complex and getting legal advice will help you to better understand your rights and responsibilities.
Leanne, there are some very common myths when it comes to family law. Let's go through a few of these. The first one is 50-50 or equal time is the standard arrangement.
The standard arrangement is what is in the best interest of your child. That's a paramount consideration.
So that's a myth.
It is.
Second one is if I don't see my child, I don't have to pay child support.
That's a myth. Your financial responsibilities to your child do not end if for some reason you do not have a relationship with them.
And if we're talking about property, you need to be divorced to do a property settlement.
That's a myth. You can do a property settlement prior to divorce.
If you've been in a de facto relationship for over 2 years, it will be a 50-50 split of the property pool.
That's a myth. No, the circumstances of the relationship and the 4-step process will be applied to any property division.
Thanks so much for sharing your knowledge with us, Leanne. I know that it will be beneficial to many. If you need family law advice, please contact your local community legal centre, and you can find them by searching Find a CLC, and you'll be able to find one in your area. We've put together a resource sheet with links to finding your closest community legal centre, as well as some very useful websites and videos. The link is in the information section under the video. To contact the Mallee Family Care Community Legal Centre, please call 1800 243 002 or visit our website mfclegalcentre.com.au. Thanks for joining us.